For motion, item number 1.
May I please, Your Lordship?
Heard and no comment on the council for the applicant. This is an application for condonation of 33 days delay in filing the collected return. Issue notice. Applicant to take steps for service of notice on the respondents 1 and 2 by registered postage one list after 4 weeks.
May I please, Your Lordships, if I may be allowed, I sincerely apologize for some mistakes. I have enclosed the wrong annexure in the application, so I may be allowed to replace it, my lord.
Petitioner is permitted to replace annexure number
G, my lord.
G.
Yes,
G
DDIA.
in the presence of the deputy registrar judicial.
Pleasure, my lord.
For admission, item number 2 and 3.
Two. Sutaka,
Lordship.
seeing your books, I think we will not even wind up today.
No, Lordship. No, Lordship. No, Lordship. We will definitely finish before first half. Lordship, we are very thankful to your Lordships. Your Lordship has been giving a very patient hearing since Monday. Lordship, I will not repeat the submissions of Mr. T.P. Jamir. I will, in some important points, I may substantiate with some law judgments in the points submitted by him. And, my lord, what I will be doing, firstly, my lord, I will give a brief summary of the submissions of both the parties, Mr. Counsel for the petitioner and Mr. T.P. Jamir, to refresh your lordship's memory. And thereafter, lordship, I will place the service rules since 1966, how the rules has been, over the years, how the rule has been amended and passed, so that you get a, lordship get a clear picture about all the rules from 1966, 1999, 2005, and 2012. Thereafter, lordship, I would like to give a brief facts about how I was born in the service. Thereafter, lordship, so certain queries raised by Honorable Justice Emma will be answered there when I highlight how I was born in the service. Just brief background about my appointment and some notings. Thereafter, lordship, I will make some legal submissions supported by judgments. My lord, now, my lord, this case has been like India-Pakistan cricket match. Both sides has been, lordship, very strong. Now, lordship, I have been taking notes of the submission by the counsel for the petitioners. Now, my lord, he was making a submission that the third amendment was done with an ulterior motive to favor respondent number 3. In fact, lordship, the missiles that has been fired by counsel for the petitioner, 70% were against me. Then, my lord, secondly, he was making a submission that chances of promotion has been affected by the amendment. Then, my lord, strong reliance was given on the cadre review committee, where he was submitting that when the cadre review committee was under process, Without awaiting for the cadre review committee, the amendment has been passed. Lordship has gone through the cadre review committee notifications. Lordship, one unique feature about all the cadre review committees, the three circulars. Circulars are members of the cadre review committee. It is not an independent body, but my lord, the members of the cadre review were all the members of the writ petitioners, and in the third review committee, I was included as a member, not an independent body. And cadre review committee was dissolved, but that has not been challenged also. I'll come to that. Then, my lord, my learned friend was making a strong submission that the immune judgment was passed, immune notification was issued in clear contravention in circumvention of the judgment dated 12/5/2022, passed in 3/23 of 2021. Then, my lord, the counsel for the petitioner were making strong reliance upon Rule 10 of 2012, which departs transferability. And he was making a submission that unequals were treated as equals. Then, my lord, my learned friend was also making a submission that the legislative process, he was referring to the file notings and the cadre review committee, is with malice, motivated. Then, my lord, he made a categorical statement. He said, "They can come, but I cannot go." I'll highlight on those issues. Then, my lord,
That is, I think, something wrong which my learned friend is referring to. They can come, but we cannot go.
yes,
That means we cannot go,
I'll
they can
explain.
come. That is in the post of steno,
I will only
OSD to the speaker, which has been created only for the stenos. So when the word only is used, then it can be meant only by the stenos. She can come to the channel cadre, that is Schedule A. But we cannot go. Why? Because the post is created only for the steno. That is what I was referring to. I think my learned friend
My
has
lord,
misunderstood.
I'm
on that line.
only giving the quotation. I have no doubt when he was making a statement, that is the phrase he used. I'll elaborate. Then, my lord, on the issue of made equivalent in the amendment, he was making a submission that though the word equivalent is used, it does not confer a right to hold a sanctioned post in the cadre. That is what also one of his submission. And then he was making a submission that the rule has been made tailor-made for respondent number 3 when she is yet to be encadred in the general cadre. Then he was making a submission that it is a clear violation of Article 13 and 14, and it is illegal, arbitrary, and unreasonable. Those are the sums in substance, subject to whatever my learned friend said. This is a few points which I could note down in his submissions, today's submission. One note, the stand of the respondent number 1, listening to his submission yesterday, which I'm adopting. My lord, Mr. T.B. Jamir was making a submission that, firstly, he was making a submission that the only ulterior motive in the present case is the motive of the petitioners, that is, from the general wing to occupy the post of additional secretary in above perpetually, excluding the members from the other wings. That was his first submission. Then, my lord, he was making a submission that executive can fill up the gaps where the rule is silent. And he was also making a submission that restructuring of the rule is the exclusive domain of the employer, and service amendment, rule amendment of the rules can be done without consent from the employees, even unilaterally. And my lord, my learned friend also was making a submission that legislature can remove the defects pointed out by law. by court, sorry. Legislatures can remove the defects pointed out by court in certain judgments. My learned friend was making a submission that malice and motive cannot be a ground to challenge the rules. And Lordship, my learned friend also was making a submission that hardships faced by the employees cannot be a ground to file a case to challenge the rules under Article 14 of the Constitution. And my lord, my learned friend was also making a very important point that power of the governor under proviso to 309 is legislative in character, and applying the same principle, my lord, the power of the governor under 183 to make rules is legislative in character, not executive. Under 187.3. And my lord, he was also making a submission that presumption, there is always a presumption in favor of the rule, conceded by my learned friend, and rule can be challenged only on two grounds, that is competency and violation of fundamental rights. Now to that, my lord, my learned counsel for the petitioner had fairly conceded in his submission. Firstly, he conceded that he is not challenging competency. That was his submission, if I remember correctly. Secondly, he also conceded that it is a established principle of law that presumption is in favor of the validity of the rules. That was his fair submission, my lord. I respect him for that fair concession, because that is the principle of law.
Under concession, Lordship, I have added one. The onus lies on the person who alleges. That my learned friend has left out.
Yes.
If he's quoting my submission,
my lord,
that was my submission.
my lord, fine, no issue, because no issue about that, my lord. I'm only, because I was just, I could not, my lord, I did not record his submission. So sums in substance, to refresh your lordship memory about the submissions the last 2 days. Now, my lord, before I go into the merit of the case, lordship may kindly allow me to refer to the rules. My lord, I have submitted, yes. My lord, it will be flagged also. I have annexed all the rules since 1966. Now, my lord, lordship may kindly allow me to, in fact, lordship, I have compiled the whole rules up to the third amendment. So if lordship, it will be easy for lordship to see everything, including the imbued third amendment I have annexed. So, my lord, kindly allow me to refer to 1966 rules first. The first one, my lord, I am referring to Rule 1. This rule shall be recalled the Nagaland Legislative Assembly Rules 1966. Then, lordship, kindly allow me to read Rule 3. Secretariat merit, lordship. The Secretariat is trained in composition. There shall be a separate Secretariat of the Nagaland Legislative Assembly, which shall consist of a post specified in the first schedule under pay, subject to the conditions stated therein, and such other posts of officers and subordinate and inferior staff as such may, in other conditions as may from time to time be considered necessary by the governor in consultation with the speaker. So, my lord, when the rule was initially, in the original rule of 1966, there was only one schedule. Only schedule 1. And, lordship, the post of ATO and transport officers and research officers, committee officers, where we were appointed in 95, 96. So, in the original survey, way back in 1966, this survey post does not exist. Then, lordship, may kindly read Rule 13. Relaxation in exceptional cases, my lord. Rule 13 is about relaxation in exceptional cases. Then your lordship may kindly see Rule 25. My lord, this is a receivatory power. So from the original, in the original rule, the receivatory power was there, subject to the provisions of Rule 12. All matters not specifically provided for in this rule, whether incidental or ancillary to the provisions of this rule or otherwise, shall be regulated in accordance with such orders as the Speaker from time to time make. Then Lordship 26, interpretation, subject to the provisions of this rule. All questions relating to the interpretation of this rule shall be referred to the Speaker, whose decision shall be final. My lord, receivatory power in interpretation 25 and 26 is unique to rule under 187.3. Not these provisions may not be available in rules under proviso to 309. So, my lord, Honorable Speaker, and under 187.3 have plenary powers, unlike, my lord, rules under 309. Now, Lordship may kindly see the first schedule. Staff strength of the Assembly of us on 1982, my lord, Secretary, Deputy Secretary, Under Secretary, Senior Committee Officer, Personal Secretary, Librarian, Superintendent, Committee Officers, Account Officers, and subordinate staffs. So, my lord, there was no post of transport. In fact, Lordship, what has happened is, so, my lord, when the rule was originally enacted, there was no separate wings. There was no, besides the strength of the service, it was not divided into different wings. All were treated as one. There was no distinction. So, my lord, the duties and responsibilities were all interchangeable in the original rules. This is what I want to show. Then, Lordship may kindly come to the next rule.
Lordships,
Kindly allow me to submit.
this matter has already been decided
Lord,
in
kindly allow me to
WPC number
submit.
323 of 2021.
Kindly allow me to
Already
submit.
decided. So to save time, Lordship, let my learned friend come to the point. What is his submission?
My lord-
Otherwise, it will be a repetition
My lord,
what has
I have-
already been decided by this honorable
I have
court.
patiently heard without any interruption for last 2 days. Kindly allow me to submit. I'm only highlighting the rules because rules are challenged. And without knowing the back foundation of the rule, how your lordship will appreciate the third amendment?
Continue.
Yes.
This issue
If he
has
keeps
already been
interrupting, it
decided.
will not end this
No,
week.
no, it's not a question of
Yes.
interruption. But
Because
I'm-
when I submit, when he's not feeling comfortable, because when I submit on the rules, there will certain lacuna which I will highlight. I'll highlight on the rules, the certain lacuna and the highlight in the rules. That's why I'm trying to go and show the rules.
no, what I was submitting was, Lordships, this issue has already been decided
No.
in 323.
No, lordship.
I will show from the judgment. I have enclosed a copy of the judgment.
I'm only,
In the present,
I'm only highlighting the rules.
I have enclosed.
Okay,
I'm only highlighting the rules.
proceed.
Then lordship may kindly come to 1999 rules. Because my lord, he said I am ex-cadre. So from the rule, I'll prove whether I'm ex-cadre or not. That's why I'm referring to all these rules to show that I'm not ex-cadre. He has alleged that I am ex-cadre.
Okay, proceed.
Now, my lord, the next rule, 1999. This is, my lord, this is important. Rule 1. In exercise of power conferred under 187, the rule was enacted on 27 July 1992. My lord, then lordship, the definitions. This rules, unless the context otherwise requires, lordship may kindly see N. Definitions. Lordship, may I read? Service. This is very important. Service means service in the Nagaland Legislative Assembly Secretariat. So, my lord, no distinction was made. We belong to one cadre, one service, and that is all the employees belongs to, my lord, Nagaland Legislative Assembly Secretariat Service. Then, lordship may kindly see Rule 10. Qualification for recruitment and promotion to any post or class of post shall be as specified in the third schedule. So for the first time, three schedules. The third schedule comes into play was enclosed by 1999 service rule. There was no schedule before that. Then Lordship may kindly allow me to read Rule 16. Other conditions of service, it is within the discretion of the Honorable Speaker. Then, my lord, for the first time, Rule 18 was inserted, relaxation in exceptional cases. My lord, it was not there in the old rule, relaxation in exceptional cases. Then, Lordship may kindly see Rule 21, restitutory powers was included. Then, Rule 22, interpretation, it is the old rules. Then, for the first time, removal of difficulties, Lordship 23. If any difficulty arises in giving effect to any of the provisions of this rule, the Speaker may, by order in writing, specify as to what appears to him to be necessary for the purpose of removing the difficulty. So this is the first time coming. That is why I'm saying, my lord, the power of the Speaker under the rule is plenary power. Now, Lordship may kindly see the first schedule there. My lord, serial number 20, 21, 22. My lord, Assistant Committee Officer, Assistant Research Officer, Assistant Transport Officer. My lord, I was appointed in serial number 22. The petitioner number 2 was appointed in serial number 21. So I was part of the service. Then, Lordship, second schedule. The difficulty, my problem arose when the second schedule was from the 1999 rules. My lord, second schedule, Lordship may kindly see 15, 16, for 11, my lord, 15, 16, and 17 is with asterisks. Lordship has found that. Then Lordship may kindly go to the next page. Serial number 11, 15, 16, and 17, the incumbents in these categories will maintain their own cadre. Lordship has found that. That's how, my lord, the trouble started for me. Now it says, I maintain my own cadre. Since that's how I started submitting representations. That's how I started submitting representation. The rules were netted without giving me the opportunity to exercise my option, and I have been discriminated. That's how I started. Now, Lordship, third schedule. Next. Third schedule, my lord. Lordship may kindly see the third schedule in the rules thereafter. Now, for the first time, the third schedule is introduced for the first time in terms of Rule 10. Now, my lord, third schedule, Secretary, Lordship, promotion from additional secretary with minimum of 2 years. Then, Lordship, below at serial number 7, Assistant Superintendent, SCU, ARO, my lord, the qualification is low. Lordship has found that. Initially, my lord, when we were appointed, well, my lord, when the petitioner number 2 and the respondent number 3 were appointed, we were appointed by the same advertisement, and the qualification in the advertisement was a graduate in any discipline. Now, by this amendment, for the post of SCO RO, qualification has been changed to degree in law. Now, Lordship may kindly see, in the same third schedule, I have marked ATO, just the third schedule, the second last. Lordship, I have marked that also. Lordship, the second last, third schedule, I have marked Assistant Transport Officer, your Lordship will find. My lord, now, the Lordship may kindly see the qualification. It is bachelor degree in automobile or mechanical. So, my lord, by 1999 rules, the qualifications has been changed. Initially, we appeared the same interview. Qualification was a degree in any discipline. We appeared for the same interview. I was appointed as ATO. The petitioner number 2 was appointed as assistant research officer. It was all treated as one. no distinction, no schedule, no nothing. Then this rule came into play. Second schedule said, I will maintain my cadre. Then, Lordship, the qualification for initial recruitment also changed. Nature of work is different from this. Now, my Lord, Lordship, kindly allow me to the next rule. My Lord, Lordship may kindly see the First Amendment. I'll go straight to the First Amendment. I'll only read the head notes. Rule was amended in the year 2005. May I read, my Lord? Notification dated 23rd February. May I read, Lordship? Lordship has found that?
First Amendment.
Yes, there it is flagged. My Lord, Lordship may kindly see the flagged portion.
Yes.
Notification, Lordship. This is 23rd February, by which the First Amendment was introduced. In exercise of power conferred under Rule 21 of the Nagaland Legislative Assembly, the Speaker is placed to make the following rules to amend the Nagaland Legislative Assembly Secretary Rules 1999 and so forth. My Lord, the learned single judge in 323 has found that this is without authority. It is because, my Lord, the amendment was passed in exercise of power under Rule 21, that is a residuary power, and not under 187.3. So applying the principle of Manipur judgment, which I was insisting to read, the learned single judge has held that it is void ab initio. So, my Lord, the First Amendment does not exist in the eyes of law because lack of competency. Because rule was passed under 21 of the Act of Rule of 1999, not under 187.3. Lordship may come to the next rule, which the Second Amendment, which is also flagged, Lordship. This is 21st August 2012. Lordships have found it. May I read, my Lord? In exercise of power conferred under Rule 22 of the Nagaland Legislative Assembly, Rules 1999, the Speaker is pleased to make the following rules to amend the rules of 1999. My Lord, initially it was Rule 21. It is renumbered as 22. Lordship may kindly see 22 is a residuary power. And Lordship may kindly see the Rule 10, where the pen and intertransferability and in the Second Amendment, which is the main plank of the submission of the petitioner, that consequent upon merit Rule 10 in the amended, consequent upon the additional rules of recruitment in condition number 10, streamlining of cadre imperatively conditionalized to appoint fresh recruitment to the lower post of the same cadre through facilitating the incumbent to the higher relevant post, whereas irrespective of relativity of post, there shall be no intertransferability between the various schedules in the even of similar scale between the cadres. This is the main block of the petitioner's submission. Now this is the learned single judge applying the principle that it is not an amendment under 187.3, held that it is void ab initio. So, my Lord, and the immune notification, the Third Amendment, Lordship has found that it is under 187.3. My Lord, it is also annexed for your easy reference. The amendment is issued under the Third Amendment was under challenge, was issued under 187.3. So competency, my Lord, in that view of the matter, my counsel for petitioner was making a submission that he is not pressing on the issue of competency. Now, my Lord, in that backdrop, the judgment of the learned single judge was passed. My lord, if your lordship may kindly bear with me and allow me to refer to the judgment of the learned single judge. My lord, page 67 to the writ petition. To the writ petition, lordship, page 67. The relevant portion, I'm going straight to paragraph 25. Rules of 19, may I read, my lord? Rules of 1999 was framed in exercise of power conference under clause 3 of 157 of the Constitution of India by the Governor of Nagaland in consultation with the Speaker of Legislative Assembly. Rule 24 of the said rules provide for repeal. It states that rules of 1966 has been repealed by the said rule, and all the orders and action taken prior to the enforcement of the rules in respect of the matter for which there was no specific provisions in the rule shall be deemed to have been validly made or taken. Therefore, the service of the respondent number 3 come to be governed by rules of 1999. Rule 10 of the 1999 states the qualification for recruitment and promotion to any post or clause shall be as specified in third schedule, although the schedule does not provide for categorization of the post under Assembly Secretariat, but the post of ATU has been mentioned separately, and it is not a fettered post for promotion to the higher grade or post. As for the post of Assistant Superintendent ATU RO, they are mentioned as a fettered post. Promotion to the post of Superintendent Committee Officer in the third schedule. In further, the post of Superintendent CU RO has been provided as a feeder post for promotion to the post of Under Secretary. Therefore, there is clearly a clear distinction drawn between the posts occupied by the respondent number 3 at the relevant time. My lord, it is because of the asterisks in the rule. 26. The rules of 1999 come to be amended by notification to the 23/5/2015, and it was known as the First Amendment. The First Amendment came into force with immediate effect from the date of its notification. It may, however, be noticed that the First Amendment was made in exercise of power conferred by the Rule 21 of 1999 by the Speaker. Rule 21 is a restitutory power conferred upon the Speaker of the Assembly. It provides that all matters where accidental auxiliary to the provision of the rules or otherwise shall be regulated in accordance with such orders as the Speaker from time to time made. From the language of the said provision, what can be understood is the matters where incidental or auxiliary to the provisions of 1999 can be regulated in accordance with orders as the Speaker may make. The said provisions otherwise does not confer powers upon the Speaker to amend the rules framed under clause 3 of the Article 187 of the Constitution of India. All that the provision provides is restitutory power under the Speaker. Then, my lord, the same principle has been mentioned in paragraph 27 with regard to the Second Amendment. Thereafter, my lord, paragraph 28. My lord, the last 4 lines in paragraph 27, kindly bear with me, the last 4 lines. Mr. Such and such, senior counsel for the respondent number 3 has argued that First Amendment and Second Amendment of the rules cannot be sustained, since the same are made in exercise of the restitutory powers conferred upon the Speaker. 28. The learned senior counsel is correct in saying so, but the fact remains. Then, my lord, the justification why I am in the separate category is given. Then, lordship may kindly come to, then, my lord, in paragraph 29. The single judge has discussed about 187.3. Then, my lord, I'm reading paragraph 31 and 32. May I read paragraph 31 and 32? Rules of 1999 was framed in exercise of powers conferred under clause 3 of 187 of the Constitution of India after it was laid before the State Assembly. As for the Office Memorandum 1/11/2021, the same does not indicate as to under which particular proviso has the powers been exercised by the Speaker. Moreover, the power to relax the rules from the language of the said provision has to be exercised only in exceptional cases when the Speaker is satisfied with operation of any law or provision in the matter of condition of service of an officer or staff serving the Assembly Secretariat has caused undue hardship in any particular case or cases. Therefore, by an order dispense with or relax requirements of rule or provision to such extent and subject to such condition as may be necessary for dealing with the case in a just and equitable manner. Rule 32, paragraph 32, in the present case, the imbued memorandum is not in respect of relaxation of rules or condition of service of the rules, but a process of restructuring cadre by encadering the post from a particular schedule to another schedule. For such an exercise has to be done in a just and equitable manner, which means that the undue hardship should not be caused to the other employees while relaxing certain provisions of the rules. As for Rule 22 of the Rules of 1999, as amended, it has been held here and above that the residuary powers given to the Speaker does not include the power to amend the rules, and therefore invoking the said rules to restructure the cadres of the post under Assembly Secretariat cannot be sustained. So this is the sole ground on which the office memorandums, office memorandums whereby service was restructured and was regularized, was set aside on the ground of jurisdiction and on the lack of, my lord, competency. Now, my lord, 35. Last 6 lines. However, my lord, however, the same shall not debar the respondent authorities concerned from considering the restructuring of the various posts under the Assembly Secretariat, which should otherwise only be done in accordance with the relevant provisions of law and by taking into consideration the rights and interests of all stakeholders. My lord, this judgment it has attained its finality. Nobody is challenged. I agree with counsel for the petitioner. But this judgment got not me, it got everyone. Because, my lord, First Amendment of 2005, Second Amendment of 2012, since it was issued in exercise of power by the Speaker under residuary power, under the rules, not under 187.3, applying the same yardstick, the learned single judge says, this is also unsustainable in law because of lack of competency and lordship. Then lordship, the Manipur judgment, paragraph 34 was submitted, whereby the learned single judge has held that when any legislation is passed without competency or in violation of fundamental rights, that is void ab initio. My lord. So in that view of the matter, lordship, the liberty was granted by the learned single judge that, look, all your amendments of First and Second Amendment is without the authority of law. It is void ab initio. So in that view of the matter, you can restructure the services in accordance with law, that is under 187.3, by taking into consideration the interests of all the stakeholders. All the stakeholders include not only the general wing, but all the eight wings. There are 8 different wings in the assembly. So irrespective of the nature of work, all has to be taken into confidence because, lordship, 2N 1999 rules says service means, lordship has rule 2N, the definitions of what is the definition of service, the employees of all the members of the Nagaland Legislative Assembly. So keeping that in mind, as my lordship, the other day, Mr. T.B. Jamir was making a submission. In that backdrop, the immune notification was issued under 187.3 to cure the defects pointed out by this honorable court. It was not in circumvention of the judgment, nor it was contrary to the judgment as alleged by the petitioner, but, my lord, with the sole intention to cure the defects pointed out by this honorable court, the restructuring was done in accordance with law under 187.3 of the Constitution of India. And, lordship, all the interests of the stakeholders from all the 8 schedules without any distinction, lordship, without any distinction is now eligible beyond the post of Joint Secretary. So where's the violation of Article 14? Or where's the question of arbitrariness or discrimination? That aspect, lordship, may kindly keep in mind. So, my lord, the only valid service rule, my lord, is the 1999 rules without the amendments and the Third Amendment, which is under challenge. So, my lord, this case has to be examined from that perspective because, my lord, this honorable court and by the operation has clearly held, and lordship is well aware that the First Amendment of 2005 and Second Amendment of 2012 is void ab initio and it is not a valid law in the eyes of law. So, my lord, Rule 10, where the counsel for petitioner were making strenuous submission that the intertransferability has been banned and this and that, my lord, is all, my lord, it does not stand the test of law in the light of the fact that rules were met without legislative competency, without authority of law. Because, Honorable Speaker, under residuary power, my lord, have no power to amend the rules. It is only the governor. My lord, in consultation with the Speaker, under 187(3), can amend the rules. So, my lord, this is one first point I would like to clarify and supplement the submission of my learned friend, Mr. DP. Now, my lord, how I was born in the Canada. My lord, that the other day, my learned friend, I'm told, has submitted my promotion and upgradation orders, but it's all part of my documents. So, my lord, I'll quickly go through and show, because, lordship, in my affidavit in opposition, I will not take time just to show my upgradation orders because he has raised strong objections to that. My lord, page 26 is that there was an advertisement in the year 1995. My lord, the type copy I also have annexed, but since it is legible, can you allow me to refer paragraph page annexure A? My lord, assistant research officer, assistant transport officer, then qualification, lordship, you can see it is a degree in arts, science, commerce for assistant research officer. For assistant transport officer is BA pass in arts, science, commerce, or diploma degree in mechanical engineering. My lord, the record shows that initially I submitted my application only for serial number 1, but after the interview, I was offered the post of serial number 2 and I accepted. Then, my lord, thereafter, lordship, my initial appointment is at page 29. Type copy is page 30, my lord. I was appointed as the assistant transport officer, my lord, and by the same interview, the petitioner number 2 also was appointed as assistant research officer. Now, my lord, lordship, you can see page 33. This is the notings of the Honorable Speaker, my lord. Merit. It appears that when we move for creation of the 3 posts, assistant committee officer, assistant research officer, and assistant transport officer, we have not specified the nature and condition of the posts for which the posts are meant to be, but rather general in nature, and accordingly, the finance department has also conveyed your concurrence. The 3 posts are identical, carry the same status and scale of pay, hence it would be appropriate to and also keep rooms for the office to assign capable person to man the post if all are treated in general cadre. Therefore, now even the ARO and ARO are appointed, you need not necessarily man the same post, but will be intertransferable, submitted for Honorable Speaker's kind perusal. Then it was approved by the Honorable Speaker. Then, lordship, may kindly see at page 34, I was my lord, in exercise of power vested in him, the Honorable Speaker is pleased to promote such and such assistant transport officer permanent against the upgraded post of senior transport officer such and such. My lord, the last line, the upgraded post with the scale of pay has been accorded by Secretary such and such. The post will be automatically stand reverted to its original post of assistant transport officer as and when the present incumbent vacates the post. Then, my lord, page 36, this is my promotion to joint secretary on the same terms and condition. Same terms and condition, my lord. Then, same terms and condition, page 37. My lord, is my promotion to the rank of Additional Secretary Transport, same terms and conditions. Now, my lord, after the judgment, then Lordship may kindly come to page 73. 73A will be the type copy. Pursuant to the verdict of the Honorable High Court in such and such, wherein the imbued such and such has been rendered as unsustainable and set aside, the Honorable Speaker is pleased to order for cancellation of the above office memorandums. Consequently, the appointment order of such and such additional secretary by the notification dated 30/11/2019 against the upgraded post accorded by notification shall be treated as revived in force. So, my lord, after the judgment by which my engatherment and regularization was set aside, the old order has been revived. So I'm enjoying that position at the moment. Now, my lord, kindly allow me. Now, my lord, the reason why I'm upgraded is because we were appointed on the same date in the general gather. But my promotion has been stuck because of the asterisks in the 1999 rules. So there was discrimination and unfairness. So in that view of the matter, the Honorable Speaker, in his wisdom, and through, my lord, drew a board, shall come to the board also, has given upgrading, promoting me to the higher grade, to the higher status, on the same scale of me, the day the petitioner number 2 was also promoted, so that there is no discrimination and unfairness against me, because, my lord, the unique feature about the petitioner the number 2 and respondent number 3 is we were appointed by the same interview and we were initially all general cadre. So to protect my interest, my post was upgraded on the same day the petitioner number 2 was also promoted till the rank of additional secretary. So that no discrimination and injustice is done to me. And since 1999, I have been submitting my representations, and I approach this honorable court seeking a direction for disposal of my representations. That's how issue has come. I'll refer to my... Now, my lord, Lordship may kindly allow me to refer to, in my page 50, my lord, page 46, to my writ petition. My lord, page 46. Then, my lord, Lordship may kindly to my writ petition. Lordship may kindly come to page 49 to my affidavit in opposition. Lordship, yes. Date of joining, the petitioner number 2 at 2nd September. Date of joining, petitioner number, the respondent on 3rd September. My lord, since this is an issue in the writ appeal, I will not go deep into this date of joining for the moment. Because, my lord, this will be a subject matter in the writ appeal. So I'm not going deep into this for the moment. But Lordship may kindly see further that it may be mentioned that such and such, the petitioner number 2 was serving as ARO on ad hoc since with effect from 10/8/1995. Page 49 to my affidavit in opposition. My lord, type copy is at page 49A. I have enclosed a type copy at 49A. So, my lord, it appears petitioner number 2 was serving on ad hoc since 10/8/95, and she appeared and qualified. So, for the purpose of 35 years of length of service, it will be counted from 10/8/95. Now, Lordship may kindly come to page 53. This is the noting of the Honorable Speaker on Lordship 16/9/2019, because Lordship will get a sense of the issue when you read the Speaker's opinion. My lord, 53, may I read, my lord? May I read? I have examined the representation such and such and corresponding petition of NASA and have bureaus and notes of the officers and documents. I am grateful to the former Honorable Speaker who minutely examined the matter as per records, documents available in the file. At the very outset, as on the matter, I am constrained to observe that both the petitioner and the association has threatened to take to court if the decision is not in their favor, which is most unfortunate. However, in view of the contents, I have called for additional records as filed. The following files, such and such, were produced. Then, number two, the relevant observation is about cadres, the Nagaland Legislative Assembly 1999, and two men cadre general in other services or ex-cadre, which is separately categorized in the schedule, third and second schedule. Three, on perusal of the notes and records in files such and such, I observed that initially the creation of the post of ATU was processed, enabling it to be ex-cadre post as proposed by the Honorable Speaker in 1991, such and such. Four, however, in the same file, the original concurrence order from the Finance Department in the original creation order to the post of Assistant Committee Officer, Assistant Research Officer, Assistant Transport Officer were normal general creation orders without any mention of ex-cadre, and even the advertisement and appointment orders were normal general orders and no mention of ex-cadre against the post. Later in the same file, the matter was processed for putting the three posts of SU, RO, ATU in the general cadre, which should be intertransferable for future convenience, which was proposed by the then Secretary and agreed upon, approved by the then Honorable Speaker, as pointed out by the in Secretary's notes in mentioned in such and such 6/8/1996, which we have just referred, Lordship. However, in spite of the above notes and decision, the Service Rule of 1999, which was prepared after proper study by the duly constituted Assembly Committee, service file whose report specifically stated the committee also felt necessary to maintain the following post. My Lord, 53 is a type copy. So, my Lord, kindly allow me to go to 54. Assistant Protocol Officer, Assistant Transport Officer, Librarian, and Receptionist as a cadre of its own and incorporate in the service rule in service, and was duly approved by the Speaker and Governor. The subcommittee on service rule was constituted by the Speaker to scrutinize the Nagaland Legislative Assembly Rules 1999 in detail, who prepared the draft. Service rules were approved by the Speaker and submitted on His Excellency the Governor on 28/7/1999 for his approval in pursuance of 187(3) of the Constitution of India. The Special Secretary to the Governor sent the draft rules to the Law Department for comments, correction, which was done, and corrected rules were submitted again by the Speaker, the Honorable Speaker, who finally approved the rules on 15/11/1999. The service rule was further amended 2005. Such and such stated that she submitted superior representation, and specifically the latest being 38/2017, seeking clarification and restoration of the originality of the post. It is, however, found that only one representation of hers was processed on such and such, recommended by the Honorable Chief Minister. Her case was processed together with another representation submitted by T.N. Lota Librarian on 15/11/2009, who submitted he was originally appointed to the post of Assistant Librarian purely on the basis of general category and not ex-category, and therefore no to accommodate him in line with general category. It is said that the matter for both cases went up in file to the Additional Secretary, who noted that incumbents were representing after 11 years of rules of 1999, which is beyond reasonable time, and the second schedule, 13/14, were very clear and specifically quoted to maintain a separate category. 7. The Service Rule of 1999 was further amended in 2012, such and such, where Rule 10B is inserted in which is said such and such. Normally, the service rules of any government organization or institution would reflect the policy of that government, organization, and institution, which is made in the interest of that organization and its members. Any individual member or group, if aggrieved by any of its provision, may pursue any possible ways and means for a retrieval of their grievance. At this point of time, owing to the facts stated above and circumstances of the case as it stands today, I am of the opinion that it would be wrong on my part to charge or reverse a decision or indecision of my predecessors, or to take any decision against a specific provision of the service rule, which I should not do so. However, I too concur with the wisdom of the former Honorable Deputy Speaker in his paragraph such and such of his observation that the matter needs to be reviewed to be fair to all cadres, so that all capable employees of different scheduled cadres should not depart from being made intertransferable or to be included in the general cadre except for technical cadre posts with specific technical qualifications to accommodate the interests of every cadre to enable capable person within the Assembly Secretariat to man the top post, proper streamlining of the service rule and the intertransferability in time of requirement or at certain level with seniority as already assigned in the rank, wherein all the employees will be clear about the prospect of their career to seem to be required and necessary exercise to be made in this regard. Meanwhile, in view of the inevitability of the top post of secretary and 2 posts of additional secretary filling vacant, exercise may be made for promotion of the joint secretaries in their respective cadres to the post of additional secretaries when they fulfill the criteria for promotion to the post, even an upgradation personnel to the incumbents of the other services if streamlining exercise could not be completed by that time. I therefore direct 1. Necessary exercise may be taken for promotion of joint secretaries in their own cadres to the post of additional secretaries when they fulfill the criteria for promotion to the post, even an upgradation personnel to the incumbents of other services as stated above. 2. To take up review and streamlining of the service rules wherein all the cadres can have a meeting point, a certain higher grade rank being promoted time to time with corresponding ranks with seniority as already assigned in the respective ranks, wherein all the employees will be clear about the prospect of their career. Office may work out the proposal in the above lines in an approvable process for calling creation board meeting. Then, my lord, finally another notings of the Honorable Speaker at page 69. That is after the passing of the judgment, my lord, where this honorable court has given a direction for disposal of my representation with a speaking order. My lord, at page 56 is the judgment by which this honorable court direct the respondent authorities to dispose of my representation with a speaking order. And this is the speaking order passed at page 69, Lordship. On 13/10/2021, page 69. Pursuant to the judgment dated such and such in WPC 20 by the Gauhati High Court, the matter was placed before me for disposal of the representation. The representation of the petitioner relates to restoration of her original placement to the general cadre. The ground on which petitioner is praying for restoration of her original placement to general cadre will be discussed hereinafter. The NASA also submitted representation opposing the representation submitted by the petitioner. I have perused the representation submitted by the petitioner and the corresponding counter representation by NASA and other relevant interconnected service and cadre issues thereof. Records reveal that the petitioner, through a series of representations, have been praying for restoration of her original placement to the general cadre. As per the record, some exercise have been made by my predecessors to address the grievance of the petitioner, and which, however, do not seem to conclusively dispose of nor specifically communicated to the petitioner. However, valuable opinions shared by my predecessor in the matter shall be relied upon for a way forward as part of my decision. Needless to reproduce the entire comment of the matter on record after examination, as the same is already reproduced exhaustively by the Commissioner and Secretary. A. As per the record, the petitioner was a direct recruit through combined competitive exam conducted to the post of such and such, which had no categorization of ex-cadre or otherwise. This is no. B. As per the record, even prior to advertisement and recruitment, the Secretariat had decided the posts of SU, ARO, and ATO being identical, carrying the same status and skill of pay should be treated as in general cadre. 3. C. It is also a matter of record that the service rule of assembly had been amended in the year 1999, whereby for the first time the transport has been categorized as a service of its own or ex-cadre. Accordingly, when general cadre the petitioner had been brought to the ex-cadre to the prejudice of the petitioner, there is nothing on record to show as to whether prior to such change in the nature of status of posts by the petitioner under transport branch, opportunity has been provided to exercise her option. D. As per the record, petitioner submitted representation against the categorization of services, which appears to have not been agreed in view of being beyond the reasonable time, while noting such and such, clubbing a representation in government TN librarian such and such, the speaker, secretary only mentioned the possible promotion of the co-petitioner and endorsed back the file without endorsement from the honorable speaker, and the matters appears to have been sidelined thereafter. Thereafter, the Assembly Secretary further amended the rules in the year 2012 in insert 10B, which departs intertransferably among various schedules of post cadres. The representation submitted by NASA against the representation of the petitioner praying for restoration of her original placement to the general category is observed to be mainly under categorization made in the year 1999 and the Rule 10. Under the given facts and circumstances and on perusal of relevant records as already mentioned, I cannot deny the presence of aberration anomaly created over a period of time to the prejudice of the petitioner, which therefore requires serious consideration, keeping in mind the interests of the NLA and also interests of the petitioner. In the light of what has been discussed above and as directed by the Honorable High Court, the representation of the petitioner is examined and considered as under. 1. I am of the opinion that when the decision has been made, as regard the nature and status of a post and accordingly advertised and recruitment made, but thereafter, changing of the status, nature and status of the said post to the prejudice of the incumbent without any reasonable basis is not justified, more so when the affected persons had not been notified nor given an opportunity. 2. By changing the nature and status of the said post held by the petitioner without giving her any opportunity, in my considered opinion, amount the deprivation of the existing rights, benefits enjoyed by the petitioner without complying with the principles of natural justice. 3. The further amendment of service rule debarring intertransferability while the categorization is under dispute, in my opinion, is not justified. In this connection, my immediate predecessor and such and such, Honorable Speaker and the Deputy Speaker such and such also observed that in order to utilize the service of all capable officers, the restriction of intertransferability is not good and accordingly suggested for streamlining of the cadre so that there is a meeting point, at least from the rank of Deputy Secretary, Under Secretary. I also agree with the observation made by my predecessor that by amending the service rules, the vested accrued rights of the petitioner has been taken away without any justification and thereby discriminating the petitioner from her colleagues who are appointed along with her on the basis of same advertisement and common selection process and without any categorization. 4. In concurrence with the opinion of my predecessor and also at pre-page by Commissioner Secretary, who himself has vast administrative experience in Lok Sabha, I concur on the point that there has to be a system where competent and capable officers are provided an opportunity to serve the Secretary without the restrictions imposed by Rule 10B, which may turn out to be detrimental for smooth functioning of the Assembly Secretary, which is an important part, being the legislative organ of the government. 5. Whereas both the effective services of two senior officers in the rank of additional secretary is pertinent for smooth functioning of the Nagaland Legislative Secretary. In the present state of affairs, keeping in mind the interests of the Nagaland Legislative Assembly Secretary in the interest of justice, I'm compelled to exercise the power under Rule 19, and he passed the order. That's how it was. Notification was issued, and then Honorable Speaker passing the order under Rule 19. Restructuring was struck down on the ground that Speaker have no power under Rule 19, but only by the Governor can amend under 187(3). So, my lord, the grievance of the respondent number 3 was not an issue, unfortunately, but, my lord, the fact that the Honorable Speaker had issued the restructuring order and my regularization by 111 orders, which was under challenge of his memorandums. It was set aside on the ground that it was without authority of law. And Lordship, appreciating the fact in the background as highlighted, Lordship, the learned single judge has given the liberty to the respondent number 1 to amend the rules in accordance with rules by taking into consideration the interests of all the stakeholders, not only the interests of the general wing, but interests of the other 7 wings also, because there are different 8 wings in the department. My lord, we have In the assembly, they have librarian, they have transport, they have legislative wings, where only low graduates are used. Then the general branch, that is the administrative branch, and then Lordship, the stenographers, then other technicians are there. So that way, my lord, the different 8 branches are there, eight schedules. For example, Lordship, the other day my learned friend was pointing out, DP, in the Department of Geology and Mining. Geology is the mother stream, but they have, my lord, drilling wing as well as chemist with different natures of work, different qualifications. So under the rules of geology and mining, they have a meeting point in the level of joint director. And single seniority is maintained from joint director onwards. Till joint director, separate seniority lists are maintained. Lordship, because from joint director and above, the nature of work is administrative. Similarly, Lordship, in this secretariat, 8 wings with separate qualifications. So they come up to the level of joint secretary in their own wings. Thereafter, my lord, above that, it is purely administrative in function, duties. So, my lord, that way it says no distinction. My lord, it is not intertransferability. My lord, the word used is we come under the different wings of the joint secretary from length of joint from the grade of joint secretary. No distinction. The separate wings categorization does not apply. We belong to the service of the Nagaland Legislative Assembly because my lord, joint secretary and words is more or less administrative in nature, and the most qualified person can go up to my lord, and the post of secretary is by selection under the rules. So the most qualified person will go beyond joint secretary to additional secretary onwards. Now, my lord, so keeping that as a background, how I was born and all that, my lord, now I will make some my other submissions. Now, my lord, the other day, I was also making a submission and reiterating that the parties are bound by their pleadings. My lord, I have submitted 211-15 SCC 453, page 607, when I was making submission on the maintainability. Lordship, it is an established principle of law that the subject matter of the case is to be confined to the prayers of the writ petition itself, not beyond. And I was making a submission the other day that it is a blanket challenge to the Rule 3rd Amendment. Now, my lord, it is also a cardinal principle of pleadings that court cannot make out the case not pleaded, and the court should confine its decision to the question raised in the pleadings only, and no party should be permitted to travel beyond its pleadings so that the other parties are not taken by surprise. Lordship, to save time, I will not refer the judgment, but Nan Kishore Lalba Mehta versus New Era Fabric Limited, 2015, 9 SCC 755, paragraph 20. That principle is clearly laid down. Lordship is well aware, but as a reminder. Now, Lordship, may kindly allow me to refer to the pleadings of the petitioner. Some portions. It is a short petition, my lord. Much has been referred, so I will not. My lord, up to paragraph 1 to 7 in the writ petitions are facts of the case. Then his submission starts from 8. My lord, I'll read only a few paragraphs. Some has been read, so I'll skip but one, just a lordship reminder. Paragraph 8, page 8 to the writ petition. May I read the lordship? That the matter thus situated, the commissioner, by notification dated 18/5/2022, on the amendment of service rule by the governor in exercise of power under clause 3 of 187, that is the impugned order. 9, the petitioner begs to state that despite initiating a committee to look into the cadre review and the service conditions, the respondent authorities has proceeded to amend the service rule in exercise of its wide power without waiting for the committee to arrive to a finding and without considering the stakeholders and seriously embedding the very intent of the said committee, the petitioner begs to state that the respondent authorities has amended the service rule in a scuttle manner without any careful consideration, and thus demonstrating the very intent that such amendments to the service rule has been made to accommodate and favor certain individuals, defeating the purpose of their own initiative of initiating the committee for amendment of the service rules. This is one. 2 points, my lord, to accommodate somebody, cadre review. Then, my lord, paragraph 10 is about short-term amendment, contract appointment. My lord, I'm not concerned with this. My learned friend has referred, P.B. Jamir has referred to this, so I'm skipping that. Then petitioner, paragraph 11, that the petitioner begs to state that the actions of the respondent authorities in amending the service rule has made the judgment redundant and ineffective. It can also be construed that amendments of the Rule 10 in A and B was a repetition of OM 11121 and Notification 11121, which was set aside by the Honorable Court on the observation that it was an attempt to accommodate a particular person in a different category. My lord, this is totally wrong statement because competency. 12, the petitioner begs to state that Rule 10B was tailored to suit certain individuals by inserting word or equivalent in the Assembly Secretariat. The petitioner begs to state that there is no substantive post in the relevant service rule equivalent to the rank of additional secretary, except making the post of OST in the rank of additional secretary. However, the post of OST is to be filled up only by stenos in terms of notification, which also clearly implies that said post is only meant for the stenos barring intertransferability of cadres. As such, the insertion of the words equivalent does not carry any meaningful and reasonable interpretation to implement the said provision, thus making it arbitrary, discriminatory, illogical, and unreasonable. My lord, serious allegation against OST, but my lord, the OST was not made a respondent in this case. And in terms of the amendment, third amendment, she is also eligible. In fact, she is the senior most in the grade of additional secretary in the moment, and my lord, because she was upgraded in the grade of additional secretary by the year 2017. We were promoted thereafter only. Yes, and in view of statement in paragraph 11, my lord, I prayed for interview. I prayed to be. I was permitted to allow to intervene because of the serious allegation, direct allegation in paragraph 11. Paragraph 13, that the petitioner begs to state that the amended rules is not a rational decision since there is no promotional avenues in the other cadre to range the rank of additional secretary or even below due to non-existence of substantive posts, thus making it apparent that only a certain individual would be benefited from the amended rules and is not interested and is not in the interest of all the employees. The situation applying the provisions of intertransferability is not even a remote possibility for any other employees to implement under Rule 10. 14. My lord, the petitioner begs to state that the amended rules, while notification dated 18/5/2022, suffers from anomalies and discrepancies and should have awaited the cadre review service rule amendment committee to arrive to a finding, instead had amended the rules in capricious and discrete manner, causing prejudice to the stakeholders. The present committee was constituted with the very purpose to review the existing service conditions, anomalies, experience in promotional opportunities. However, the respondent authorities had amended the said rules in a manner which is unreasonable without taking into account the stakeholders and without awaited report by the said cadre review committee, thus frustrating the very intent of the formation of the said committee. It is pertinent to mention that the issue in the impugned service rules was within the purview of the cadre review committee for scrutiny. The said action resorted to by the respondent is like placing the cart before the horse, and as such, the same is unreasonable, arbitrary, and which calls for interference into this honorable court. Then, my lord, 15, the petitioner begs to say that the entire exercise of amending the rule is arbitrary, illegal, discriminatory, and the same was amended without taking into consideration the rights and interests of all the stakeholders. Then 16, my lord, begs to state that the imbued rule was an act to defy the findings of Honorable Court in 323. Then 17, the petitioner begs to say that the action of the respondent authorities is to amend the service rule without taking into consideration the implication and outcome of such action, which is bound to cause prejudice to the employees. It is arbitrary. Then amended service rule is not workable. Paragraph 18. So these are the, my lord, these are the grounds. These are the pleaded statements. These are the grounds on which this petition has been filed. And Lordship, I'm repeating again that, my lord, this honorable court cannot make out a case not pleaded. I'm repeating again. So, my lord, going through that, the pleadings of the writ petitioner, my lord, since, my lord, competency has been considered and presumption in favor of the rule has been acknowledged, the only issue involved here is, my lord, a peer reading of the imbued Third Amendment, whether the fundamental rights has been violated or not. That is the only issue. Whether the petitioner's fundamental rights has been violated. Now, my lord, it is not the case of the petitioner that now, in view of the amendment, his promotion is blocked. Hardship may be there, but his chance, the right to be considered for promotion has not been taken away, has not been deprived. Chances of promotion is not the condition of service, my lord. And when there is amalgamation or when there is restructuring of the service rule, definitely there will be a heart burning. Some may be benefited, some may lose something, my lord. It may bring hardship. In fact, the judgment was submitted by my learned friend DB on this. So hardship cannot be a ground to challenge the rules. So, my lord, that aspect has to be kept in mind. Not what fundamental rights of the petitioners has been violated. But going by the pleadings, my lord, cadre review committee, contravention of the rules, my lord, alleging motive and malice upon the respondent authorities, my lord, all has been dispelled by the judgment submitted by the other day by Mr. T.P. Jamir. Those are not grounds. Now, my lord, Lordship may kindly allow me to show the work distribution over the years. Because, my lord, I'm transport, they are general. So, contention of the petitioners all along is that I cannot go there nor ticket come. Now, my lord, to my affidavit in opposition, page 38. In my affidavit in opposition. My lord, this is a work distribution on 16 January 2020. My lord, serial number 2, the petitioner, my lord, besides transport, I have been given assigned other responsibility, that is protocol. Now, my lord, serial number 4 is petitioner number 4. Lordship, KWP Kapi, Joint Secretary, he's the petitioner number 4. My lord, serial C. He was assigned the duty of transport. Then, my lord, serial number 5. She's the petitioner number 4.
Number 4 is petitioner number
3.
This 5 is
Petitioner number 4. My lord, then lordship. So, my lord, petitioner number 3 was granted assigned duty of transport. Lordship, you kindly see. And besides transport, I was given duty of protocol. Then, lordship, you kindly see page 39. Serial number 7. My lord, this Mr. Lota belongs to general cadre, serial number B, he was assigned duty of transport. Then Norshim Mekani C, serial number 14. Mr. Bagai Indang, he's the president. He's the petitioner number 1. President of NASA, my lord. His duty, Lordship Mekani C, serial number A, transport. Then Lordship Mekani come to page 41. This is another duty responsibility, delegation of duty on 23rd July 2020. Now, my lord, I am at serial number 3. I've been assigned protocol precise transport. Petitioner serial number 4 is petitioner number 3, Lordship. He has C, transport. Then Lordship Mekani C at page 42, next page. My lord, serial number 9. Serial number 9, Lordship. He is also the officer from the general wing. It's C, transport. Then, my lord, serial number 14, the president, petitioner number 1, transport. Then, Lordship Mekani come to page 74. It's 11th May 2022, my lord. Now, serial number 3, precise transport, has been given many other responsibilities. Then, my lord, serial number 4 is the petitioner number 3, transport at serial number 6. My lord, type copy is 74A. So, my lord, over the years, my lord, no distinction has been made. In fact, the officers from the general wing has been occupying the transport wing all along, till date. Till date they are occupying. And they are saying that I cannot come there. They can come, but I cannot go. You want to occupy everything. That is how my learned friend was speaking about the ulterior motive of the general wing to have a hegemony. Lord. To fax it at the murder. Fax it at the murder. That's what Saka. Fax it, clarify. I need to clarify the facts. That's why I'm compelled. My lord, I'm compelled to go to the facts because the question of axe cutter was raised. That's why I'm compelled to go into the facts to show how how I was born in this service. My lord, besides transport and the men, general wing, lordship, there was also a post of additional secretary in the general wing also, in the library wing, lordship, but already retired. So, my lord, that in my affidavit in opposition, lordship, may kindly see at page 76, just to bring it to your lordship notice, that, my lord, the Inyam Bemolota, who was submitting representation along with me as recorded in the speakers, he was also promoted to the upgraded to the post of additional secretary library. Thereafter retired, joint secretary and additional secretary. So, lordship, 30th November 2019, page 76, annexure O. So, my lord, it is not only from the stenos and the general wing and the transport. My lord, even from library wing, people has been promoted up to the grade of additional secretary. Now, lordship, so that way, my lord, living playing field was maintained all along. Now, lordship, kindly allow me to submit, refer to the representations of the writ petitioners. What was your stand? Because my learned friend did not refer to his representations. Lordship, to the writ petition at page 92. First representation was at Annexure J, page 92, 21/4/2020.
Yes.
My lord, kindly allow me to read. My lord, I am to skip that. I am reading the third paragraph to save time. Other cater posts such as stenographer, transport, library, legal, IT, and the watch and war Nagaland slaves were created for specific technical purposes, possessing requisite qualification for the post, and there should be no intertransferability between the various castes. Hence, this post should not be merged with the general cadre. However, the functions, rules, and jurisdiction of other posts are well defined in the respective schedules of the rules. So, my lord, the members, the association has been submitting representation against their own members because we're all members of NASA. One. Then, lordship, may kindly come to page 81. My lord, this is a representation submitted on 23/6/2020. My lord, to save time, I am reading at page 82. May I read? The second paragraph. For cadre review, the creation board in their sitting in the year 2017 has agreed and approved in principle regarding the structural hierarchy of the Nagaland Legislative Assembly Secretariat as submitted by the subcommittee. Therefore, the association requests the authority to implement the service cadre review. So more avenues are created for the upcoming officers and staff of the Secretariat. My lord, there was a cadre review in the year 2017, which is not part of the circulars. I'll come to this. In regard to service rules, the association feels there are several rectification, addition, deletion needed to be done. As such, the association requests your authority for amendment of the Nagaland Legislative Secretariat Rules Recruitment Conditions 2012. So, my lord, the petitioner association has been praying to the government for amendment of the rules as far back as 2020. Lastly, the association assures our full cooperation and support with the authority to ensure that all policies are successfully implemented for the welfare of the officers and staff, and also request the authority to consider our demands for smooth functioning of the Secretariat. Now, my lord, the cadre review of 2017, paragraph 2. My lord, in the affidavit in reply of the writ petitioner, at page 121,
To which
to my affidavit in opposition.
page?
Page 121. Merit. The Honorable Creation Upgradation Board of the Assembly Secretariat had its sitting on 25th October 2017 under the chairmanship of the Honorable Speaker with all the members present as under. My lord, the board members, I'm not reading. The board opened its meeting with a welcome address by the chairman and who also explained the purpose in calling this board meeting and asked the commissioner secretary to initiate the discussion of the proposal. The report minute of the cadre review committee earlier circulated, was in principle accepted and taken up the recommendation of the committee for creation and upgradation. Having elaborately deliberated on recommendation item-wise, the board had approved for creation, upgradation as under OST, one post to be graded and filled up by senior-most stenographers, joint secretary library to be upgraded from chief library personnel, joint secretary transport to be upgraded from senior transport officer, personnel to the incumbent. So, my lord, it was on the basis of a cadre review committee approved by the board. Whatever action has been taken. And lordship may kindly see deputy secretary. Next page also you see deputy secretary and words. Now, lordship may kindly read that in the light of page 82 to my writ petition, paragraph 2, which that we have just the representation which you have, lordship has just referred. Page 82, the representation. In my writ petition, page 82. Page 82 to the writ petition, I'm sorry, lordship. Page 82 to the writ petition. Please read paragraph 2 again. For cadre review committee, lordship, may I read? 82 to the writ petition that we have referred. So for cadre review, the creation board in their sitting in the year 2017 has agreed and approved in principle regarding the structural cadre hierarchy of the Nagaland Legislative Assembly as submitted by the subcommittee. Therefore, the association requests the authority to implement the service cadre review so that more avenues are created for upcoming officers and staff of its secretariat. So, my lord, the petitioners association has supported and prayed that the cadre review committee recommendation whereby the OST post was created, we were upgraded, librarians were upgraded, so that more avenues to be created. They are not petitioners are not expected to blow hot and cold on the issue because they have all along supported. So, my lord, the creation and upgradation was not out of the blue. It was through a cadre review committee and through a board. Not an arbitrary exercise of power to favor someone, as alleged by the petitioner. That is what I am trying to show. Now, my lord, the circulars of the cadre review committee, my lord, which is at page 96 onwards to the writ petition, which was referred to the other day, where all members of the petitioners, my lord, page 96. My lord, lordship may kindly see the members. Committee consists of the following. Petitioner number 2 was made the chairman, page 96, my lord. I'm sorry, page 96. Page 96. Petitioner number 2 was made the chairman, then the OST, then the general secretary of the association. Petitioner number 4 is petitioner number 3, serial number 3. Then lordship may kindly see the next page, 97. Same. Then, my lord, 98. Now, my lord, more members from the general wing were included. Then, my lord, page 100. The respondent number 3 was also included as a member. So, my lord, all this appointment of the cadre review committees was to review the service rule by the petitioners, by the members of the association themselves, not an independent body. Whether that is fair or not, whether I can be master of my own action. Well, usually cadre review committee is from the highest authority independent body, like 2017. Now, my lord, to my writ petition. To my affidavit in opposition. Page 77 to 83. But not to save time, I'm not reading. These are page 77 to 83 are representations submitted from the other branches, other wings in support of the amendment. But not page 77, then page 80, then 81, and my lord, page 83 are representations submitted by the members from the other schedules, other wings, other than the general, who submits sufficient representation in support of the third amendment. Because, my lord, now no distinction. Now, my lord, in annexure S, there was a controversy with 83, and in the affidavit in reply, my learned friend has made a submission that Mr. Wongdo, serial number 2, has forged the signatures of serial number 3. Now, my lord, with electronic evidence, the petitioner, the Wongdo Jomir, has submitted representation before the Honorable Speaker that he had a discussion, and on the day when the representation was submitted, his friends were out of station. So through a telephonic call, he was authorized and he wrote his name on behalf of all. And representation is submitted before the Speaker with electronic evidence that is their discussion. If that is an issue, I will reply in due course. But the fact remains, that is how, my lord, I was making a submission that the association does not, the petitioner number 1 in the present case does not represent the interest of all the stakeholders. It is only under the guise of NASA. Petition was filed only for the purpose of benefiting, protecting the interest of the general.
Who are the members of NASA,
All the officers and staff below Joint Secretary,
including all this
Lordship,
scheduled
everyone,
eight wings?
all the 8 wings. All the 8 wings. Contributions also, everyone, contribution must have been given. Now, my lord, cadre review, my lord, cadre review, lordship, 27/3/2022, it was dissolved. It is part of the affidavit. In page 19 of the governance affidavit, the dissolution order is there. So a lot of issue has been raised, that is not challenged. When the dissolution order is not challenged by them, whether they have a grievance to show the cadre review without waiting for the cadre review committee, they have come. Now, on the issue of process, now, my lord, after this, I'll submit my legal submissions. On the issue of process, now, my lord, I'll come with the judgment. In fact, the judgment by the Honorable Supreme Court is very clear. Dr. Ashwini Kumar's judgment, I'll refer again, which says, my lord, wisdom of the legislature cannot be challenged on the principle of separation of power, and the legislative process is not subject to judicial review. Now, my lord, so, my lord, now kindly allow me to refer to the judgments.
Yes.
Now, that is the factual submissions.
Mr. Siti, you are saying you are representing the cause of all the members of NASA.
Yes, petitioner number 1.
Yes. But here we see that the different wings are supporting the amendment.
Some wings,
Not all the wings, except your general wing.
others have also joined.
That part you should clarify. That's what
Yes.
I'm just because before we forget that part, you can just write it down.
Yes.
Okay, proceed.
No, my lord, this is the state of Manipur, Soja Bomar Ograng. Under
Ograng.
that, yes, lordship must be aware. So, my lord, paragraph 18 and 19. This is what. May I read, my lord?
This reported in any,
My lord, I've tried my best, but I could not obtain it. I'll try my best again tonight. If possible, I'll supply the citation. Paragraph 18 and 19. Lordship must be aware of this case. Parliamentary secretaries.
yes,
May I read paragraph 18 and 19? Where a statute is adjudged to be unconstitutional, it is as if it had never been. Rights cannot be built up under it. Contracts which depend upon it for their consideration are void. It constitutes a protection to no one, and no one who has acted under it, and no one can be punished for having refused obedience to it before the decision made. Norton versus Shelley County observed that an unconstitutional act is not law. It confers no right, it imposes no duties, it offers no protection, it creates no office, it is in legal contemplation as inoperative as though it had never been passed. An unconstitutional law, be it either due to lack of legislative competence or in violation of fundamental rights guaranteed under Part 3 of the Constitution of India, is void ab initio. In such and such, it was held by the Constitution bench of this court that the law-making power of the state is restricted by a written fundamental law, and any law enacted and opposed to the fundamental law is in excess of the legislative authority and is thus a nullity. A declaration of unconstitutionally brought about by lack of legislative power, as well as a declaration of unconstitutionality brought about by reason of abridgment of fundamental rights, goes to the root of the power itself, making the law void in its inception. Such and such summarize the following proposition. A, whether the Constitution affirmatively confers powers on the legislature to make laws subject-wise or negatively prohibits it from infringing any fundamental rights, they represent only two aspects of one of legislative power. B, the Constitution in express terms makes the power of a legislature to make laws in respect to the entries in the list of the 7 schedules subject to other provisions of the Constitution, and thereby circumscribes or reduces the said power by the limitation laid out in Part 3 of the Constitution. It follows from the premises that a law made in derogation or in excess of that power would be ab initio void. My lord, the learned single judge in 323, paragraph 24, had accepted my submission and this judgment. In that view of the matter, Lordship, Second Amendment, First Amendment and Second Amendment of 2005 and 2012 is void ab initio. So it doesn't exist in the eyes of law. One. Now, my lord, on the other day, my lord, my learned friend, D.B. Jamir, has submitted a judgment, 1980 supplementary SCC 524, page 44 and 45. My lord, it says that Yadav's, my lord, my lord, P.S. Yadav in others versus State of Haryana. P.S. Yadav,
1980, no?
1980 supplementary SCC 524 and paragraph 44 and 45. My lord, the proviso to Article 309 provides insofar as material that until the state legislature passes a law on the particular subject, it shall be competent to the governor of the state to make the rules regulating the recruitment and the condition of service of the judicial officers of the state. The governor thus steps in when the legislature does not act. The power exercised by the governor under the proviso is thus a power which the legislature is competent to exercise but has in fact not yet exercised. It partakes the characteristic of the legislative, not executive power. It is legislative power. That the governor possesses legislative power under our constitution is incontrovertible, and therefore there is nothing unique about the governor's power under proviso to 309 being in the nature of a legislative power. So deriving this analogy, my learned friend was making a supposition that the rule passed by the governor in the present case under 187.3, it is legislative in character, in exercise of his legislative power, not executive. Now, my lord, in my lord 2020, kindly allow me to read this again. 13 SCC 585. My lord, it is Dr. Ashwini Commerce. I need to read this because my learned friend has read, DB has read only a few sentences there, but clear picture will emerge when we read this judgment. Now, my lord, paragraph 10 to 16 and 33. 2020 13 SEC 585, paragraph 10 to 16 and 33.
Can you please repeat the page?
My lord, 585. 2020 13 SEC 585. Lordship, may kindly, I'm calling for the, I have filed my list of document books also. So it should, I would like to, now here, my lord, on the separation of power, what the Honorable Supreme Court has said is that court can examine the legality and validity of the legislature or the government action, but court cannot examine the wisdom behind the legislative measures or relative merits or demerits of the government's action. That is one principle. Secondly, my lord, it puts a restraint upon the legislature to declare a judgment as invalid by enacting a law. However, my lord, Honorable Supreme Court says, but it permits the law. Constitution permits. It is good to remind ourselves. May I read my into the functions and tasks performed by the other branch, it checks consideration of power in a particular branch or an institution. The legislature, as an elected representative body, enacts laws to give effect to and full democratic aspirations of the people. The procedures applied are designed to give careful thought and consideration to wide, divergent interest, voices, and all shades of opinion from different social and political groups. My lord, I'm reading paragraph 12. The executive has primary responsibility for formulating government policies in proposing legislation which has been passed by the legislature become laws. By virtue of Article 73 and 160 of the Constitution, the power and function of the executive are wide and expansive. They cover matters in respect of which parliament, state legislatures can make laws and vest with the executive of the authority and jurisdiction exercisable by the government of India or the state government as the case may be. As a delegate of the legislative bodies and subject to the terms of the legislation, the executive makes second stage laws known as subordinate and delegated legislation. In fields where there is no legislation, the executive has the power to frame policies, schemes, which is coextensive with the power of the parliament or the state legislature to make laws. At the same time, the political executive is accountable to the legislature and holds the office till enjoy the support and confidence of the legislature. Thus, there is interdependence, interaction, and even communality of personnel members of the legislature and the executive. The executive therefore performs multifarious multifunctional rule and it is not monolithic. Notwithstanding the multifunctional and pervasive rules, the constitutional schemes ensures that within its interdependence there is a degree of separation that acts as a mechanism to check indifference and protection and protect the non-political executive. Part 14 of the Constitution of India to service under the union and the state, recruitment, tenure, terms and conditions of service, persons of serving the union or a state in accords to a substantial degree of protection, office of province such and such. 13. The most significant impact of doctrine of separation of powers is seen and felt in terms of institutional independence of the judiciary from other organs of the state judiciary. In terms of personnel, the judges is independent judges, unlike members of the legislature, represent no one, strictly speaking, not even the citizens. Judges are not accountable and answerable to the political executive is to the legislature and elected representatives are to the electorate. This independence ensures that judges perform the constitutional function in safeguarding the supremacy of the Constitution while exercising the powers of judicial review in a fair and even-handed manner without pressure and favors. As an interpreter, guardian, and protector of the Constitution, the judiciary checks and curbs violation of the Constitution by the government when they overstep their constitutional limits, violate the basic structure of the Constitution, infringe fundamental rights, or act contrary to law. Power of judicial review has expanded, taking within its ambit the concept of social and economic justice. Yet, while exercising the power of judicial review, the courts do not encroach upon the fields marked by the Constitution for the legislature and the executive, as the courts examine the legality and validity of the legislation or the governmental action, and not the wisdom behind the legislative nature or relative merits or demerits of the government action. Neither does the Constitution permit the court to direct, advise, or sermonize others in the spheres reserved for them by the Constitution, provided the legislature and or the executive do not transgress their constitutional limits or statutory conditions. Then, my lord, next page, paragraph 14. Constitutional bench such and such has uniformly ruled that the doctrine of separation of power, not specifically engrafted, is constitutionally entrenched and forms part of the basic structure as it sweeps operation and visibilities are apparent. Constitution has made demarcation without drawing formal lines, almost the three organs with the duty of the judiciary to scrutinize the limits and whether or not the limits have been transgressed. These judgments refer to the constitutional scheme incorporating checks and balances as a sequator, that is, another consequence. The doctrine restrains the legislature from declaring the judgments of the court to be void and of no effect, while the legislature still possesses the legislative competence of enacting and validating law, which remedies the defect pointed out in the judgment. However, this does not ordain and permit the legislature to declare a judgment as invalid by enacting a law, but permits the legislature to take away the basis of the judgment by fundamentally altering the basis on which it was pronounced. Therefore, while exercising all important checks and balances functions, each wing should be conscious of the enormous responsibility that rests on them to ensure that the institutional respect and committee is maintained. Then, Lordship, kindly allow me to read 33. Paragraph 33. I'm reading the quotation. There can be no manner of doubt that the parliamentary wisdom of seeking changes in existing law by means of amending lies within the exclusive domain of the legislature. It is not the province of the court to express any opinion on the exercise of legislative prerogative in this regard. The framing of the amendment bill, reference of the same to the Parliamentary Studying Committee, the consideration thereof by the said committee, the report prepared along with the other steps that are required to be taken, the time frame thereof are essential legislative function, which should not be ordinarily subject to interference or intervention of the court. The constitutional doctrine of separation of powers, the demarcation of the respective jurisdiction of the executive, the legislature, and the judiciary under the constitutional framework would lead the court to the conclusion that the exercise of amendment of the act, which is presently underway, must be allowed to be completed without any intervention of the court. Any other view or any interference at this juncture would negate the basic constitutional principle that the legislature is supreme in the sphere of lawmaking. writing down a statute to make it workable in a situation where an exercise of amendment of law is pending will not be justified either. A perception, however strong, of the imminent need of the law engrafted in the act and its beneficial effects on the citizenship of a democracy by itself will not permit the court to overstep its jurisdiction. Judicial discipline must caution the court against such an approach. My Lord, the submission of the learned friend against that the respondent had circumvented the judgment of 323 by the learned single judge, that it is in contradiction of 320 judgment of learned single judge 323, my Lord, has to be read in the light of this judgment. The process, the legislative process is outside the purview of this honorable court under the power of judicial review with due respect and lordship. The wisdom cannot be challenged. My Lord and lordship, now what has been changed? Earlier, lordship, only the general wing were eligible to go beyond till the apex from the post of additional secretary onwards. This honorable court gave a direction, the single judge, that now you are given liberty to amend the rules in accordance with law by taking all the stakeholders into consideration. So, my Lord, the defects has been cured and the enactment was passed under 187.3, and all the members, irrespective of wings, without any distinction beyond joint secretary. Some may not, some from some wings, nobody may reach there. But as a matter of principle, nobody is discriminated. So where's the violation of Article 14? Or where's the violation? Or whether, my Lord, the amendment of the rules has met the, my Lord, judgment of the, whether in any way it has affected or superseded the judgment of this honorable court. Rather, my Lord, as rightly pointed out, the defects has been cured. Now, my Lord, and the scope of judicial review of amendment of rules, my Lord, kindly allow me to submit the judgment. 2019, 6 SCC 674. I read only one paragraph, 6.5. 2019, 6 SCC 674, paragraph 6.5. My Lord, yes, it is in page 683. You'll find it in 683. May I read, Lordship? 6.5. From the aforesaid, it appears that UPSC give its concurrence after having due deliberation and consideration the relevant factors, and only relevant rules come to be amended, and two posts in question come to be equated. We have carefully considered the submission made on behalf of the both parties. Question relating to the constitution, pattern, nomenclature of posts, cadres, categories, their creation, opposition, prescription of qualifications, and other conditions of service, including avenues of promotion and criteria to be filled for such promotion pertain to the field-up policy, is within the exclusive discretion and jurisdiction of the state, subject, of course, to the limitations or restriction envisaged in the Constitution of India, and it is not for us statutory tribunals at any rate to direct the government to have a particular method of recruitment or eligibility criteria or avenue of promotion or impose itself by substituting its view for that of the state. Similarly, it is well open and within the competency of the state to change the rules relating to a service and alter or amend and vary by addition, subtracting the qualifications, eligibility criteria, and other conditions of service, including avenues of promotion from time to time as the administrative exigency may need or necessitates. Likewise, the state, by appropriate rules, is entitled to amalgamate the departments or bifurcate departments into more and constitute different categories of posts or cadres by undertaking further classification, bifurcation, or amalgamation, as well as reconstitute and restructure the patterns and cadres and categories of service as may be required from time to time by abolishing the existing cadres, posts, and creating new cadres and posts. There is no right in any employee of the state to claim that rules governing condition of his service should be forever the same as the one when he entered service for all purpose and except for ensuring or safeguarding rights or benefits already earned, acquired, or accrued at a particular point of time. A government servant has no right to challenge the authority of the state to amend, alter, or bring into force new rules relating to even an existing service. Then, my lord, I'm submitting another judgment. 1998, 4 SCC 598, paragraph 1 to 4, paragraph 7, paragraph 4 to 20. 1998, 4 SCC 598, Lordship, paragraph 1 to 4, paragraph 7, 4 to 20. The matter on chances of promotion and treating unequals as equals by amalgamation of cadres by rules. That is on that subject. Because my learned friend was making a strenuous argument that unequals has been treated equals. My lord, yes, kindly allow me. My lord, kindly allow me to read paragraph 2, how it was. My lord, under the notification, a central level service was created by merging the following three cadres. Three cadres were merged, my lord. Then, according to appellant, the three cadres, which were so merged, were having different statutory functions, different qualifications, and different duties and powers. By merging the three cadres, unequals have been treated as equals. The appellant and similarly placed officers belonging to Central Industrial Relation Machinery have thereby been placed in a position much worse than the position they occupied in their original cadres. By reason of the merger, his chances of promotion have been substantially diminished. He therefore challenged the exercise of power under 309 of the Constitution, on the ground that it is violative of 14 and 16. Now, Lordship, you kindly see paragraph 7 on the top, my lord. A cadre review committee was headed by the cabinet secretary from member with representatives from all the ministries. My lord, the first 10 lines. That's how a cadre review committee was: independent, representative from all the ministries under the chairmanship of the cabinet secretary himself. Now, my lord, the last 5 lines below. It is therefore felt that the constitution of a unified cadre was in public interest. Hence, the merger took place. Since this is essentially a matter of policy, the scope of review by the court is limited. We can, however, examine the grievance of the appellant relating to unequals being treated as equals, and the grievances relating to losing promotional avenues. Then, Lordship, may kindly go to paragraph 14. These are short paragraphs, Lordship. Narrate. The cadre review committee, from 14, my lord. The cadre review committee, after examining the kinds of duties discharged by these officers, decided that since they all work in the area of labor welfare, it would be desirable that they would widen their experience. This would be possible if the cadres are integrated and the posts are made interchangeable, so that members of the cadre could get a more varied experience in different areas of labor welfare, thus making for a better equipped cadre. Therefore, although the exact nature of the work done by the three cadres was different, it would be difficult to say that one cadre was superior or inferior to the other cadre or service. A decision to merge such cadre is essentially a matter of policy. Since the three cadres carry the same pay scale at the relevant time, merging of the three cadres cannot be said to be cause any prejudice to the members of any of the cadres. Total number of the posts were also increased proportionately when the merger took place, so the percentage of posts available on promotion was not in any manner adversely affected by the merger of the cadres. The appellant, however, contends that as a result of the merger, his promotional chances have been adversely affected because his position in the seniority list has gone down. Rule 9 of the rules under which the merger is affected lays down the rules of seniority. It provides the inter-se seniority of the officers appointed to various grades mentioned in the Schedule 1 at the initial constitutional stage of the service shall be determined according to length of regular and continuous service in the grade, subject to maintenance in the respective grade of inter-se seniority of officers recruited in the respective original cadres. I'm reading paragraph 17. Explaining the proviso, the respondents have said that before 30/12/27, 1972, assistant labor commissioners were in the higher pay scale than labor officers. The parity between their pay scale came about only from January 1973. That is why, to preserve their inter-se position, assistant labor commissioners were appointed prior to 31/12/72 have been placed above labor officers. Similarly, regional labor officers through a higher pay scale than senior labor officers prior to 1980. The parity thus come about in 1980, and hence regional labor commissioners holding to such posts on or before 2/3/80 have been placed above senior labor officers. The seniority rules have thus been carefully framed, taking all relevant factors into consideration. The respondents have also pointed out that as a matter of fact, by reason of the merger, the appellant has not in fact suffered any prejudice and he has also received promotions. However, it is possible that by reason of such merger, the chance of promotion of some of the employees may be adversely affected or some others may benefit in consequence. But this cannot be a ground for setting aside the merger, which is essentially a policy decision. This court in such and such examined the condition. Change in the promotional policy was challenged on the ground. As a result, service condition of the respondents were adversely affected since his chances of promotion were reduced. Relying upon the decision in the such and such, this court held that a mere chance of promotion was not a condition of service, and the fact that there was reduction in the chance of promotion would not amount to a change in the condition of service. In the premise, we do not find that there is any adequate ground for setting aside such and such. So, my lord, the question of treating unequals as unequals has been dealt with. Now, my lord, on Article 14, 2009, for SCC 753, 13 to 17. My lord, Honorable Supreme Court has held in this case that while dealing with Article 14, court should be conscious that Article 14 should not be stretched too far, as it would make the administration impossible. My lord, 753, and I'm reading paragraph 13 to 17. My lord, your lordship will find it in 757. My lord, after this, I'll refer two judgments and I'll conclude. Yes. I'm reading from 13. In the present case, what we find is that rules such and such of 2004 rules had done away with the requirement of passing a qualifying examination for diploma holders, junior engineers for promotion as assistant engineers, and they have been placed on a bar with degree holder junior engineers for this purpose. We see no unconstitutionality or illegality in the same. It is entirely for the authorities to decide whether the degree holders and diploma holders should be treated on a bar or not for the purpose of promotion from post of junior engineer to the post of assistant engineer. Mr. Such and such, learner senior counsel for the appellant submits that degree holder junior engineers have always been treated differently from junior engineers who are only diploma holders for the purpose of promotion, and the latter have always been required either to get the requisite qualification or pass the qualifying examination. In our opinion, merely because in the past they have been treated differently does not mean that they cannot be treated identically subsequently. In our opinion, Article 14 should not be stretched too far. Otherwise, it would make the functioning of the administration impossible. The administrative authorities are in the best position to decide the requisite qualification for promotion for junior engineer to assistant engineer, and it is not for this court to set over your decision like a court of appeal. The administrative authorities have experience in administration, and the court must respect this and should not interfere readily with the administrative decision. To treat the decision to treat all junior engineers, whether degree holders or diploma holders, as equal for the purpose of promotion is a policy decision, and it is well settled that this court should not ordinarily interfere in policy decision unless there is a clear violation of some constitutional provisions or statute. We find no violation in this case. In Tata Cellular, Union Vidya, it has been held that there should be judicial restraint in administrative decision. This principle will apply all the more to a rule under Article 309 of the Constitution. So we can read that 187.3. My Lord, I'm submitting a judgment 2016 2 SCC 445, paragraph 64 and 65. My Lord, a statute cannot be struck down on the ground that it is arbitrary. Now, my Lord, can you allow me to make a submission here before I go to the judgment? Over the years, my Lord, the Honorable Supreme Court has made a distinction between arbitrariness and manifest arbitrariness. Arbitrariness and manifest arbitrariness. What is manifest arbitrariness? Lordship, I will come later on. But just because it is alleged that it is arbitrary, cannot be a ground to struck on the statute, and the specific pleading of the petitioner and supplication, it is arbitrary. Now, my Lord, Lordship may kindly come to 445, 753, I'm sorry, then paragraph 64 and 65. Merit, page 4, it will come at page 481. Merit, my Lord. From the above extract from McDowell and case, it is clear that the courts in this country do not undertake the task of declaring a piece of legislation unconstitutional on the ground that the legislation is arbitrary. Since such a wisdom implies a value judgment, and courts do not examine the wisdom of the legislative choice unless the legislation is otherwise violative of some specific provisions of the Constitution. To undertake such an examination would amount to virtually importing the doctrine of substantive due process employed by the American Supreme Court at an early point of time while examining the constitutionality of Indian legislation. As pointed out in the above extract, even in the United States, the doctrine is currently of doubtful legitimacy. This court, long back in A.S. Krishna Estate of Madras, declared the doctrine of due process has no application under Indian Constitution, as pointed out by Justice Frankfurter. Arbitrariness became a mantra. I am submitting a judgment. Malice not a ground to challenge the rules, and there must be a manifest arbitrariness in the plenary. 2021, 5 SCC 1. Paragraph 56 to 62. My Lord, may I read? My Lord, page 60. Lordship have found it? It is with a bold head note. Challenge to plenary legislation, and what are the grounds? The grounds on which plenary law can be challenged. My Lord, this will be my last submission. No. The grounds on which plenary law can be challenged are well established. In the first two decades, decisions of this current court unerringly point out to three grounds which render legislation vulnerable. A law can be successfully challenged if, contrary to divisions of powers under Parliament or the state legislature, usurps powers that does not fall within the domain, thus rendering it incompetent to make such law. Secondly, a law made contravening fundamental rights guaranteed under Part 3 of the Constitution of India would be visited with unconstitutionality and declared void to the extent of its contravention. Needless to say, a law within the meaning of Article 19 of the Constitution would remain valid qua a non-citizen. Thirdly, apart from fundamental rights, the supremacy of the Constitution vis-a-vis the ordinary legislation, even when the law is plenary legislation, is preserved with the view that legislation must be in conformity with other provisions of the Constitution. Well, on breaches of the fundamental rights, furnishing a blank of attack against plenary law, it is necessary to notice a challenge to law under Article 14 was essentially confined to law being class legislation. In other words, a law, if it manifested reasonable classification for treating different persons or things differently, the law would pass muster. Now, my lord, I'm jumping to paragraph 58. But the following caveat by the learned single judge is worth noticing. This, however, does not mean that judges are to determine what is for the good of the people and substitute their individual and personal opinions for that of the government of the day, or that they may usurp the functions of the legislature. This is not your province, and although there must always be a narrow margin within which judges who are human will always be influenced by subjective factors, their training and their tradition makes the main body of the decision speaks with some same voice and reach impersonal result, whatever their personal predilections or their individual backgrounds. It is the function of the legislature alone, headed by the government of the day, to determine what is and what is not good and proper for the people of the land, that they must be given the widest latitude to exercise their function within the ambit of their powers, else all progress is barred. But because of the Constitution, there are limits beyond which they cannot go, and even though it falls to the lot of judges to determine where those limits lie, the basis of their decision cannot be whether the court thinks the law is for the benefit of the people or not. Cases of this type must be decided solely on the basis of whether the Constitution forbids it. The seed of this idea had a muted growth. It was in the decision of such and such that this court laid a bare new dimension in the majestic provisions of Article 14. This court took the view that arbitrariness and fairness are sworn enemies. The guarantee of Article 14 is not confined, in other words, to it being a prohibition against equals being discriminated against unequals being treated alike. Such state action must be fair and not arbitrary. If it is to pass muster in a court of law, it is essentially following the dicta laid down in our forces judgment of this court. It will be noticed that the constitutional bench in such and such stated that it is settled law that subordinate legislation can be challenged in any of the grounds available for challenge against plenary legislation. This being the case, there is no rational distinction between the two types of legislation when it comes to this ground of challenge under Article 14. The test of manifest arbitrariness, therefore, as laid down in our forces judgment, would apply to invalid legislation as well as subordinate legislation under Article 14. Manifest arbitrariness, therefore, must be something done by the legislature capriciously. Capriciously means unpredictable, change at the drop of a hat, irrational, and or without adequate determining principle. Also, when something is done which is excessive and disproportionate, such legislation will be manifest arbitrary. We are therefore of the view that arbitrariness, in the sense of manifest arbitrariness, as pointed out by us above, and would apply to negate the legislation as well as under Article 14. So, my lord, whether the present legislation amendment is capricious, irrational, or without adequate determining principle, whether it is excessive or disproportionate, that has to be examined. Now, my lord, this view, namely that be it a plenary law, if it is found to be manifestly arbitrary, it becomes vulnerable, has been following the following decision among other judgments. Yet, another ground recognized by this court is that a law, be it offspring of a legislature, it falls foul of Article 14 if it is found to be vague. It must be elaborated. We must remember the case involving overturning Section 68A, 6A of the ID Act, which purported to create a criminal offense, the ingredients of which were found to be vague. My lord, whether the Third Amendment is vague or not, well, on the basis furnished under law for impugnning the plenary legislation, we may notice two grounds which has been urged before us by some of the petitioners. It has been urged that law was created by way of pandering to the real estate lobby and succumbing to their pressure or by way of placating their vested interests. Such an argument is nothing but thinly disguised attempt at questioning the law of the legislature based on malice. A law is made by a body of representatives of the people when they act in their legislative competence capacity. What is being ruled out is ordinary law. Should the same legislature seek to amend the Constitution, they should be acting as members of the Constituent Assembly. Well, it is ordinary legislation, whether it is ordinary legislation or amendment of the Constitution, the activity is one of making the law. Well, malice may furnish a ground in an appropriate case to veto administrative action. It is right that malice does not furnish a ground to attack a plenary law. So, my lord, motive, malice. So, my lord, in this perspective, laid on by the Honorable Court, my lord, this has to be examined. So, my respectful submission, my lord, is that no fundamental rights has been violated, a fair rating, and, my lord, rather, by the amendment, the defects has been cured. In no way, Lordship, the respondent has tried to circumvent or supersede the judgment of this Honorable Court. My lord, the basis, the fundamental has been changed now. Instead of one wing, officers and staff from all the 8 wings, irrespective, once they reach the level of Joint Secretary, my lord, without any distinction, all will be eligible. So, my lord, in that view of the matter, my lord, since my respectful submission is that the petitioners has miserably failed to make out a case, and it should be summarily dismissed. Much obliged, Lordship. My lord, my lord, the Manipur judgment, my lord, is a 2022 SCC online. 2022 SCC online SC 130. 2022 SCC online sub SC 130. Much obliged, Lordship.
Tomorrow. How long will it take?
Considering the submissions made by my 2 other learned friends, in fact, I deserve to take 2 days, but then I will not take that much, more than an hour, Lordship.
Hopefully, we can conclude.
Surely, Lordship,
Otherwise-
provided if
It will have to be released from part 3.
So, only his clarification, Lordship, so substantial hearing completed.
Agree. Yesterday's thing. So, written arguments.
We'll submit tomorrow.
By tomorrow, please.
Lord Chief,
Tomorrow, please, again tomorrow.
tomorrow.
Tomorrow we'll give you a free hand. Yes.
May please, Your Lordship. Your Lordship, I beg to mention item number 4. That,
Item 4 is related to item 2 and 3.
yes, is pertaining to the vigilance and the Lokayuta. So I have not received any instruction from the Lokayuta. So a short time will be given to seek instruction from the Lokayuta.
Yeah.
No objection.
Oh, where is the steno?
Still.
Item 2, 3, 4. Heard Mr. Fosiko, Learned Counsel for Petition.
Lordship.
On request made by M. Tim Song, Learned Additional Advocate General. List the matter after
3 weeks.
3 weeks. Yeah.
Objection, Lord. For motion, item number 1.
Yeah, please, Your Lordship. Lordship, my senior is in court number 1. Kindly let this matter take after some time.
Depending on the survival of the costless.
Yes, Lordship. It's a request.
Yes. Next.
For admission, item number 5.
Your Lordship, here, as per the instruction of the Honorable Court, I have given instruction from the department, but I received a bulky documents because I have to submit a report. But those documents are not legible. That's why I have just returned the documents to the department for getting the legible one. So I may require for some time. So
Lordship, that depends on the contents of the
Yes.
document, Lordship.
You're directed to file complaints report only,
yes.
nothing else.
So compliance report, there is a bucket documents, but in the compliance,
How can you have bulky documents
No.
when you are filing compliance report? Compliance report is just 1 page.
no, one
I'll
page
give
is,
you time to file compliance report again.
Lordship,
Heard
and Lordship,
MS
if you
Lucino, Learned Counsel for the petitioner. Mr. M. Tim Sung, Learned Counsel appearing for respondents. 1 and 3.
1 to 3.
1, 2 and 3.
1, 2, 3.
1, 2 and 3 is allowed another 2 weeks.
Your Lordship, all the missionaries of the state are
That I
engaged with
don't
the
know.
election.
That I don't know.
So up to 3 weeks.
Lordship, if you can kindly peruse the order 5, 12, 22,
I've
Lordship.
seen, I'm on that page.
Lordship.
This is for personal appearance.
Lordship.
But anyway, I'm giving him one last chance.
Lordship.
He's allowed 3 weeks time to file compliance report. Stop. If no compliance report is filed by the next written date, this court shall pass appropriate orders for personal appearance of respondents 1 and 3.
Like,
For admission, item number 6.
May I please, Your Lordship? Lordship, I have taken with the consent of the petitioner's counsel as well as the other respondent counsel, respondent number 9, and the government, that the matter come up on the 9th of March, Lordship.
Yeah, Rongson,
Yes, Lordship.
on request made by Mr. C.D. Rongson, and counsel for respondent number 8, is the matter on 9th March. 9th March.
Much obliged, Lord.
For admission, item number 7.
Yes.
Your Lordship,
Yes, in this
the
case, I'm
Central
looking
Council
for
is yet to file affidavit in opposition.
CGC,
Yes.
CGC as well as state respondent.
state respondents.
Yes, Lordship.
Who appears for state?
Moa Im Chen.
Respondent number two in favor, state respondent.
Your good name, please?
SK Achumi.
SK Hart MS SK Achumi. Letter counsel for the petitioner. Stop. None appears for the Union of India. Stop. MS
On behalf of Lordship.
MS
Lordship.
Inahuli Leonard, government advocate.
On behalf of.
Appearing on behalf of respondents 1 and 2. 1, 2.
Two and
Two
three.
and three.
More intern is appearing.
Two in
No,
three.
no, 2 and 3. On behalf of
and
respondents, 2 and 3. Is allowed how much time?
3 weeks, Your Lordship.
3 weeks.
Your Lordship, let interim be continued.
To file counter affidavit. Interim order passed to continue. Till the next.
Much obliged.
Item number 8.
May I please, Your Lordship? On 16/12/2022, instead of considering the IA, a consensus opinion has been arrived.
16, 12.
Yes, Lordship.
Oh, in the order was passed in the IA? I think it was passed in the IA. Yes. Yes.
So this can be disposed of, Lordship, because matter is very short. The writ petition has been filed by a person who is not a tenderer. The writ petition has been filed questioning the award of works for construction of Treasury Office at Chosupa. Now, NIT has been called, but the writ petition has been filed on the ground that no NIT has been floated. I have enclosed all the documents here, and the writ petition has been filed after 11 months.
After award of tender, award of
Yes, out of the work, 11 months, 13 days. And 42% of the work has already been completed. I have enclosed all the documents in the IA.
IA.
Yes, the last page, Lordship will find. Annexure J, page 34. This is the progress of the work. But interim order has been passed on the day of motion because, yes, because a direction was issued to my learned friend to get instructions about the position of the work. But then, unfortunately, no information could be furnished on that day. Therefore, this honorable court was compelled to pass the interim order. There is nothing wrong on it because no instructions were there. But then now that after getting the notice, I have filed the affidavit in opposition as well as the IA for getting the
So
interim order.
your challenge is on 3 grounds.
Yes,
NIT was called,
yes,
despite the agreement that NIT was not called.
yes,
Writ petitioner is not a tenderer,
yes,
and then the work has been completed 42%
yes.
on the 3.
And the writ petition has been filed after 11 months of award of the work. So there is,
By then 42% has been done.
yes,
Yes, Imti, have you filed your affidavit?
Your Lordship, I'm yet to file.
This is the problem, no.
Yes, that's the problem.
There is an interim order working against the private respondent. He has taken 4 grounds,
My lord.
which unless the writ petitioner disputes, are solid grounds.
Yes, Your Lordship. Even my petition is very clear because there has been there are the 3 respective departments involved in this case, Lordship, which are all disputing the material facts that has been produced are all disputed. Which I have also filed my rejoinder, Lordship.
State will have to,
Your Lordship, am I allowed to file a week time? Because everything is ready.
I'm not giving you beyond 1 week.
Okay,
There's already an interim order working against
yes,
the private
yes,
sector.
Lordship.
1 week time,
That was also because you couldn't get the instructions.
yes.
Lordship, so far as interim order is concerned, by operation of law, the interim order stands vacated, Lordship.
Why?
Because after serving the notice, the matter could not be heard within 14 days. So the operation of Article 226, Clause 3 will be applicable, Lordship.
But then the order of 16/12/2022,
Lordship.
because of that order, it can be applied. Anyway,
Lordship, if the respondent, if the state
I'll
respondents,
give a fixed date.
Lordship, that is better, yes.
Fixed date. On that day, if no affidavit is filed, it will be disposed on the basis of materials available on the Lordship.
Lordship.
Heard Nito Koza, Leonard Counsel for Petitioner. Also heard Mr. Siti Jamal, Leonard Senior Counsel, assisted by Mr. Aliba.
I am Chen.
I am Chen, Leonard Counsel, for respondent number
Respondent number 4.
6.
Yes.
Respondent number 6. Stop. Mr. M. T. Song, Leonard Additional AG, is allowed 1 week time as last chance to file counter affidavit. Today is 2nd. List the matter on 13th of February 2023. If no affidavit is filed by the state respondents, this case shall be
Lordship,
disposed of.
13th, I have some difficulty that Somuto FL is fixed in the principal seat on 14th, so I have to travel on 13th.
Oh. Then 15 again you will be traveling.
Yes. A date before that, Lordship.
10th.
Yes.
On 10th February. Huh? If no affidavit is filed by the next suitable date, this case shall be disposed of on the basis of materials available on the court.
For motion, item number 1.
Yes, Joshua.
May it please your lordship. No, lordship, this is pertaining to the delay in appointing the petitioner lordship.
Gambura.
That's Ganbura lordship.
Let us hear what the government has to say.
Your Lordship, as of now, notice may be issued, Your Lordship.
Okay, I'll issue short notice. You file your affidavit. He says that he is entitled to be appointed as Gambura.
Yes, lordship.
Heard Joshua Shikil and the counsel for petitioner issue notice. MS Inahuli,
Yes, Your
Government Advocate, enters appearance and accepts notice on behalf of
1, 2, and 3.
on behalf of respondents 1, 2, and 3. Extra copies. You furnish extra copies.
My lord. Lordship.
Petitioner to take steps for service of notice on respondent number 4 by registered post
My lord.
AD within 1 week from today.
My lord.
List the matter after 4 weeks.
My lord.